Welcome to In the Name of the Law, with your host, Liisa Speaker from Speaker Law Firm. Joining her today is Stephen Sinas from Sinas Dramis Law Firm, Amy Bailey from Bailey and Terranova Attorneys at Law, and Mary Chartier from Chartier Nyamfukudza PLC. Now, let's discuss some remarkable stories and real cases.
Hello, I'm Liisa Speaker with the Speaker Law Firm. Hope is crucial to moving forward in life. Today's episode is about finding hope in difficult situations. Stay tuned for this episode and hear about some inspiring stories.
In the name of personal injury law.
Hello, this morning I have with me Steve Sinas and Steve Weston. They're both attorneys at the Sinas Dramis Law Firm. Steve Sinas is in the Lansing office and Steve Weston is in the Kalamazoo office. I know Steve Weston has represented burn survivors for 34 years, so the topic we have today is the hope that we can learn from these burn survivors.
Yeah, so our firm has been around for almost 70 years doing all types of personal injury work, and we look at it like we're equipped to handle any case involving somebody who sustained serious injury. But we were so happy and excited to have Steve Weston join the firm last year because of his unique experience representing these uniquely injured burn survivors. And so I want to hear from Steve today, and he can tell us more about this area of representation.
Right. Well, what is unique about representing burn survivors, Steve?
Well, there's really a couple of aspects that are different with burn survivors. First of all is the nature of the injuries, both physically and psycho-emotionally. And secondly is the different way that the attorney representing those survivors needs to prepare and get to know the survivors and represent them. So both the lawyer's job and the burn survivors' extent and nature of injuries are both unique.
And aren't the way these people are injured usually, it's complicated to figure out, right? You need experts, you need all types of workup.
People are wrongfully burned through a variety of mechanisms. Over the years, we've handled cases of flammable vapors that have ignited as a result of being sucked into water heater air vents. We've had cases of propane being delivered to homes, and the pressure checks and the leak checks weren't done according to code. And so propane escapes into the home and ignites, and there are large explosions with fires. We've had gasoline vapors in workplaces ignite. There have been electrical explosions through faulty work done on the electrical equipment. And the list really goes on and on. Scald burns is a huge area of concern. So the mechanisms are varied, and it is really important early on to get in and collect and protect and seize the evidence as to the origins and cause of the explosion or the burn so that we can determine later on what happened here.
Sounds like there might be a whole host of types of damages that these burn survivors suffer. Obviously starting with the psychological damage of being a burn survivor. Can you tell us a little bit more about the damages?
Yeah, it's very, very common with burn survivors to go through multiple phases after their burn injuries. Most of our clients are burned over significant percentages of their total body surface. Many of them involve the face and other visible parts of their body, and many of them don't. And there are parts that they can keep covered with clothing. And the psychological impact of those different burns are different. There is something called the hidden burn syndrome that patients suffer from, that when they have burn injuries and scarring that they can cover up or hide, they tend to have a more difficult time recovering from the presence of their burns than those patients who have very visible burn scars, because they learn earlier how to cope with public perceptions. There is also the psycho-emotional process that's caused by searing pain during the treatment process, during the grafting process, whether it's an autograft, which comes from your own skin, and the donor sites are super painful. The debridement process, or cleansing of the burn wounds, and the wrapping and replacement of the skin that has been burned off, is excruciatingly painful the first time, but it's the second time and the times after that that really gets the patients depressed, because they know what's coming now. And most of these seriously injured burn survivors go through a period of time where they want the treaters to let them die. And the unique and really awesome thing about representing and working with these families is that we get to be part of the treatment team. We get to be part of the burn team to work them through and be sure that they get hooked up with the kind of counseling they need, so that they can go through that let me die phase and start to have hope that they can participate in life in a meaningful way, and that their life is not over. And that is a very rewarding thing about working with these folks. In fact, I will say that in 3+ decades of working with folks with broken limbs, who frequently let that define what they can be as a person, burn survivors, once they get through the emotional gauntlet of the treatment, tend to be some of the most uplifting and appreciative people in their view of life. And they really teach us about the privilege that we have of working with these people, because most of the things that make us angry are just inconveniences compared to what these burn survivors go through, and they are just courageous, really wonderful people.
Well, are there groups that provide support for the burn injury victims that, to help them get to that point where they have hope again?
There are, and oddly enough, one of the premier groups in the nation and the world is based out of Grand Rapids, Michigan, and that's called the Phoenix Society. And the Phoenix Society for Burn Survivors is focused upon taking the survivor and helping them literally rise from the ashes, like the phoenix bird, and support them in walking forward in life and finding meaning, success, and fulfillment as a burn survivor. Annually, the Phoenix Society hosts in different cities around the country what's called the World Burn Congress. And that is for burn survivors to come and attend, and there are scholarships to help them to do that. And what they do is they bring survivors together with treatment providers and professionals who care for them, and provide resources, information, referrals, and fellowship and brotherhood and sisterhood, so these people help each other realize that there is a future hope for more life.
Thank you, Steve.
You're welcome.
In the Name of Personal Injury Law is brought to you by the Sinas Dramis Law Firm. In the Name of Family Law.
I have with me today Amy Bailey, a family law attorney with Bailey Terranova in Okemos, Michigan, and also Karen Gallagher, a mental health therapist and the owner of the Wellness Institute of Michigan. And today we're talking about parents dealing with each other, parents who have either never been married and are having to deal with each other, or parents that have been divorced and are dealing with children's issues post-divorce. So I understand that there are two different types of custody: legal custody and physical custody. Ideally, parents will agree on how they're going to arrange their lives, but can you explain the difference between the two types of custody?
Certainly, Lisa. We have physical custody, and then we have legal custody. Physical custody would be where the children actually reside. The legal custody is decisions relating to the children's health, education, and welfare. You also have two types of custody when you're considering those custody situations as well. With physical custody, you can have sole physical custody, you can have joint legal custody. If you have sole physical custody, the child resides primarily with you. In a joint custodial arrangement, that's more of an equal parenting time schedule. We have the same situation with legal custody. You can have sole legal custody and joint legal custody. Usually you see joint legal custody, so the parents are both involved in decisions relating to their children's health, the children's education, and the children's welfare.
So what kind of examples can you share with us about where parents maybe aren't getting along, that they may have to go back to court? What types of issues come up with these custodial relationships?
Certainly. Unfortunately, there's a lot of situations that arise. For example, we could have a situation where education is an issue, where a parent decides they want their child to go to a private school and the other parent does not. Or they want their child to attend a different elementary school and the other parent does not. For example, if you have a situation where one parent moves to another school district, the other parent remains in the same school district where the child can still attend there, but this parent that has moved believes that their school district is better. We see parents bickering about that a lot, and we of course encourage them to look at what is benefiting the child.
So there was last year a Supreme Court case where the parents could not agree on the preschool for the child. And I really want to ask Karen, what do we do with these parents who are having so much trouble getting along at that early stage where they can't even agree on the preschool? What happens? What do you recommend?
We like to refer parents back to actual facts. What is making the decision about the preschool choice? Are you looking for a better education? Well, have you researched what school actually provides the better education from a ratings standpoint that is an objective piece of information, and have them fall back onto that so that it becomes not an emotional piece but also an objective piece as well.
Thank you. And I see a lot of disputes regarding medical decisions where the parents maybe don't agree on the right type of medical treatment for their children. Amy, what kind of legal recourse is there when the parents aren't agreeing on medical issues?
Well, again, if parents cannot agree, then they leave the decision regarding what's in the best interest of their child up to their judge, which is unfortunate. But I have seen scenarios where a parent will believe that their child suffers from a certain illness. They have a doctor that supports that diagnosis. The other party disagrees with it. They find a doctor that supports that there isn't a diagnosis. I've seen situations where parents cannot agree on how to wean a child from medication. And who's suffering in that situation? It's the child, which is very disturbing, obviously, to our courts. Again, encouraging parents to try to work together. I'm sure you've seen those situations as well with medical issues.
We have, and we've seen cases where physicians have just gone ahead and made decisions when there's joint legal, and they've just had to make a decision because it's been an urgent or emergent situation, and they have to listen to just one parent to treat. And I mean, I don't know what the fallout is on that kind of a situation, but they have an urgent or emergent situation and they have to act. We do see those circumstances internally, and we do recommend that they try to work through, try to find a compromise, again, falling back on the facts, trying to find mutual facts that are agreeable to both parties, and thinking about the best interest of the child. We talk about helping the parents figure out ways to concede. If you concede, you're actually still not hurting the child. You might be conceding your own wishes, but the child is going to actually end up in a good case situation and in good care. So you can also look at alternatives. Well, if we don't go to these two doctors, let's find this third doctor. We both agree that the third doctor is great. Why don't we focus on doing that, and we can drop these other two because we're in two different places with that.
And that sounds a lot better than having a judge decide
Definitely.
what is going to happen to your child's life. And isn't that what's left if the parents can't agree? They have to have a judge decide it?
They have to have a judge decide.
Yeah. I mean, I'm sure you can think of cases where the parents just don't agree on anything. If they have joint legal custody, what's really going to happen when it goes before a judge?
Well, the judge is going to look at the harm that has come to the child. If the parents are unable to reach agreements regarding these various issues as far as health, education, and welfare, and that child has been harmed, the judge will make a decision based upon what's best for this child as to which parent should have sole legal. And then that parent will be the ultimate decision maker. And so that's why it's so important. If you've decided to have this child together, you need to be able to work together to make important decisions.
So how do we handle, Karen, the emotional issues that arise when parents don't agree on important issues that affect the children?
We try to help the child set their own boundaries with the parents, and what I mean by that is they make their own decisions in terms of what's best for them. I'm just going to go to bed at 9 o'clock because I think that's best for me, and that might be within the parent's framework. So we're trying to help the child have a sense of independence, especially if they're age appropriate. So that they don't become involved with that parental discord that's going on, and keeping them comfortable. We do see quite a bit of anxiety with children, so we try and manage the anxiety from an external standpoint too, either with meds or what have you.
So we've talked a little bit about education and medical issues, but what about when parents are having difficulties with extracurricular activities, like signing up a child for a sport that requires practice during the other parent's parenting time? Amy?
We see that a lot as children get older, obviously. They want to be a participant in sports activities. And the courts, of course, want the parents to agree, so then they assure that both parents will get that child to the sporting activity. But sometimes we have situations where one of the parents says, that's my parenting time, that child is not participating. So then we end up having to go to court to discuss with the judge what's best for this child.
Thank you, Amy. Thank you, Karen.
Thank you, Lisa.
In the Name of Family Law is brought to you by Bailey and Terranova Attorneys at Law. Go to WLAJ.com for more information on today's topics and to view other In the Name of the Law episodes. In the Name of Criminal Defense.
Good morning and welcome. Today we're going to talk about the exoneration of Ladora Watkins, who was falsely accused and served over 41 years for a crime he did not commit. And I have a special guest with me today, Marla Mitchell-Cishon, who is the director of the Innocence Project at Western University, Thomas M. Cooley School of Law, and along with Mary Chartier and Chartier Nyamfukudza, who are the founding partners of Chartier and Nyamfukudza. Welcome, everybody. So I wanted to start off by asking, how was it that Mr. Watkins was falsely accused of murder?
Mr. Watkins was falsely accused of murder primarily from what we would call an incentivized witness, an individual who was implicated in the murder himself, but gave information to the police to take the heat off of him.
Okay, so tell me about how he was incentivized. What caused him to want to point the finger at somebody else?
It's a very complicated case in that a young school teacher was murdered and a police officer was actually involved in the murder, we believe. And so this individual, Travis Herndon, came forward to the police and implicated Ladora Watkins as the shooter in the actual murder.
So give us a little bit more background of the case. I mean, was Mr. Watkins even at the scene of the crime, or was the I'll call him a snitch for lack of a better term, was he at the scene of a crime? Tell us a little bit more about what happened in this case.
Mr. Watkins was absolutely not at the scene of the crime, and while he did know Travis Herndon, he had no connection whatsoever to the murder. Unfortunately, one of the reasons why the witness implicated Mr. Watkins is they had recently had a falling out, and he was looking for someone to throw under the bus, so to speak, and implicated Watkins as the shooter of the crime.
And Lisa, you use the term snitch, which really indicates that someone might know something and then reveal it. In this case, and so many cases that we work on, they're not really snitches or informants. They're people who, as Marla said, are incentivized. They're getting something from it, either immunity, as in this case, they're getting a reduction in sentence on another case, they're getting a prosecutor who will go to the parole board for them on a different case. So that's where I think Marla comes up with that term incentivized witness, because they have a motive to fabricate testimony. They can't be paid necessarily in money, but they're getting paid in really the biggest commodity for someone who's in jail or prison, which is time. They're getting these really large time cuts.
So tell us a little bit about, with this case. So the person I called a snitch was Mr. Herndon, right? And what did he end up getting for testifying falsely against Mr. Watkins?
Well, what happened was he came into the police station as a suspect in another matter. He indicated that he knew something about this murder because he was actually present at the time of the killing. That was when he implicated Mr. Watkins. Unfortunately, what happened after that is that the police department that he walked into was not the Detroit Police Department. It was Highland Park. So the Detroit police and a prosecutor got involved, and after interrogating Herndon, they basically gave him immunity for the murder to implicate Mr. Watkins. The actual other perpetrator of the crime, we believe today, was a police officer who mysteriously ended up dead shortly after this interview. And according to Herndon, who later recanted his implication of Watkins, he tried to make the record straight, so to speak, but no one would listen to him.
So let's talk a little bit about how you and your clinic went about getting Mr. Watkins exonerated.
Yes, unfortunately, we were unable to exonerate Mr. Watkins based on all the bad acting, based on the incentivized testimony. Mr. Watkins was in prison for almost 42 years. We actually originally investigated his case to try to find DNA evidence related to some hair that was collected at the crime scene. But unfortunately, we were unable to locate any of that hair. Mr. Watkins was a pretty good advocate for himself in this case, and he actually won a reversal on his own by the Michigan Supreme Court. And I will never forget that day as long as I live. My staff attorney walked into my doorway, told me Mr. Watkins had won a reversal, that his case was going back to the circuit court in Detroit. And I simply said, you know what we're going to do. And we jumped in. And our primary role at that point was amending the post-conviction motion and actually challenging more directly the hair evidence that was collected.
So yeah, let's talk about forensics for a minute. How did that play into this case?
Yes, it's really important to talk about forensics because it's a close second to one of the leading contributing factors to wrongful convictions. And in this case, it was a very horrific murder scene. A woman was shot in the head, and there was blood, obviously, at the crime scene. But what became the focus, ironically, were several hundred hairs that were collected from basically the bed where the victim was found. And what the police officer who analyzed the hair and compared the hairs concluded, which is completely unbelievable, by the way, is that one hair found at the crime scene was consistent with Ladura Watkins, and the other hair was consistent with Travis Herndon, the incentivized witness, thus sealing their case, placing both men at the crime scene and bolstering falsely the credibility of Travis Herndon.
But hair science, and we know that, we handle a lot of forensics in our cases. Hair science is bogus science. I mean, and the FBI themselves has come out with reports that indicates that all of this testimony about hair analysis and hair matching is just flawed scientific evidence. And you have somebody like Ladura Watkins who spent over 41 years in prison because of it.
And is it anything more than somebody just looking through a microscope and perhaps saying, this looks like the other and that one doesn't?
Right. It's nothing more than that. There's no scientific basis for hair comparison.
And had Mr. Watkins ever been at the residence of the victim?
Not to my knowledge, no. He did not have a connection to her at all.
So I really want to know, is there anybody that served time rightfully for this horrendous murder? Obviously, Mr. Watkins was innocent, but did anybody end up serving time for that murder?
No, and that's one of the many unfortunate consequences of a wrongful conviction, because if the wrong person is behind bars, then someone who actually perpetrated the crime is free.
Well, luckily, Ladura Watkins had you and everyone at the Cooley Innocence Project to help him, and now he's out. If you're interested in learning more about the Ladura Watkins case, please check out our podcast, Constitutional Defenders. It's on cndefenders.com, or we're on iTunes or a number of other platforms where you can watch our podcast. Thanks so much, Marla.
Thank you.
In the Name of Criminal Defense is brought to you by Chartier Nyamfukudza PLC.
Well, folks, we had a great episode today. Thank you for bringing on some fabulous guests, and they gave us a lot of hope and a lot of things to think about with the Ladura Watkins exoneration. with Steve talking about surviving burn injuries and also living with co-parenting and dealing with custodial situations post-divorce.
Yes, I'd like to just comment quickly about that. As we discussed, it's so important for parents to work together to discuss issues relating to their children. The children's hope, of course, is that their parents will get along and be able to make decisions without having to go back to court. That's also the court's hope, is that parents realize that they have to look out what's best for their children, not what's best for them.
Right.
Yeah, and when I think about the concept of hope, obviously it's this idea that things will get better or that the future will be brighter. And so when I think about Steve Weston and his presentation about representing those who survive burn injuries, he's dealing with people whose lives are forever altered and damaged because of severe burns, but they still find a way to be hopeful. They find a way to move forward. And Steve obviously is very inspired by that, and so am I.
And I think for Mr. Watkins, having spent 41 years in prison for a crime he did not commit, didn't have anything to do with, and still to hold on is a tremendous example of hope.
You have to be a really strong person to survive that long, knowing that you're wrongfully in prison.
Absolutely. I mean, 41 minutes for a crime he didn't commit is too long.
And his family.
Right. And he lost his entire life. He went in when he was 19, and when he was 61 is when he finally got released.
But he always had the hope that somehow, some way he could get released, which is pretty remarkable.
Yes.
And thanks to the hard work of the Innocence Project.
Yes.
I mean, we have a couple of Innocence Projects in the state of Michigan, and we're, I think, really fortunate to have two really strong programs here in Michigan that are working to fight for these people who are wrongfully convicted.
Yes, indeed. Absolutely. And that, of course, impacted not just him, but all his family and friends. And yes, it was great.
One thing about all these stories about hope, as a lawyer, I think you can use your experiences and the people you represent to really be grateful for what you have, and always know it could be worse, and always know to have the hope that, you got to keep on carrying on and things can get better.
Yeah. I mean, as an appellate attorney, a lot of times people are coming to me in very stressful situations. And especially if there's a custody battle and they've lost in the trial court. And, whatever happens on appeal, I think they just have hope that, we can try to tell their story to another court and convince the higher court that the trial court made a mistake. And we're able to do that a lot of times, not always, but they have to have hope and, to keep plugging along and getting through the days.
It's not a quick process at all.
It is not.
Well, fortunately, it's not 41 years
Right.
Indeed.
for parents in custody battles.
That's right.
Exactly.
And burn injury victims, obviously, that's the rest of their lives are impacted every single minute.
Physically, and also, they walk around and everybody notices their burns, and they just have to have the hope, in that sense, that people will still recognize them for who they really are.
Right.
So that's a fascinating experience that they have to endure every day.
Well, thank you, everybody, for sharing today. We appreciate it.
Thank you, Lisa.
Thank you for joining us today for In the Name of the Law. Please go to WLAJ.com for more information on today's topics, and please join us next week for another informative show.